Okay.
Thank you, Lola. Thank you, everyone, and welcome once again. So, my name is Ifeoma Ben. I'm a partner at the Law Suite, and I have the privilege of moderating this webinar. And once again, I welcome every one of us to today's webinar. So today's topic, speech, screens, and statutes, navigating free expression in the digital age, couldn't be more timely. So as technology reshapes how we communicate, we're constantly challenged to balance the right to free expression with the responsibilities that come with digital communication. So today we are privileged to have two leading voices in law and technology, Mr. Solomon Okedara and Ms. Mojirayo Ogunlana. Both of them have made significant contributions to human rights and digital freedom across Nigeria and West Africa. So they have very intimidating profiles, and time will not permit me to give us all the details about who they are. I'll just give us just a glimpse about them, and you get to know them more as they discuss this topic. Solomon Okedara is a Nigerian lawyer, researcher, and consultant with nearly 2 decades of experience in human rights, data protection, and digital law. A legal researcher at Columbia University's Global Freedom of Expression Project. He has led landmark cases advancing free expression and advised global institutions on digital rights governance. We are privileged to have Solomon here. Solomon, you are most welcome.
Thank you so much. It's great to be here.
Thank you. We also have Mojirayo Ogunlana, who is a Nigerian digital rights lawyer and principal partner at M.O.N Legal. With over 13 years of legal experience, she champions free expression and internet freedom through strategic litigation across West Africa, winning landmark ECOWAS cases on censorship, gender rights, and digital access. She advocates open, rights-based governance. Once again, we are privileged to have Mojirayo. You are welcome, ma'am. Moji, are you here? Can you hear me? If you are muted, please.
Thank you very much. Thank you for that introduction. I think I like you better than my own profile.
Thank you. So I had earlier introduced the topic. So this afternoon, we are going to be listening to, in fact, it's going to be like a discussion, not a lecture. So we are going to have the privilege of having them discuss the topic, speech, screens, and statutes, navigating free expression in the digital age. So I will proceed to ask some opening questions to our distinguished speakers. So let me see if I will spotlight. Yes, so Mr. Solomon, I would start with you for, of course, the two speakers would answer the question. So how do you define free expression? Because before we go into the nitty-gritty of our discussion today, we need to really understand the terms, the subject matter. So how do you define free expression in today's digital age, especially within the Nigerian and African context? And I will also ask a follow-up question, an additional question. You can address them together. So what are the biggest legal or regulatory challenges currently facing online expression in Nigeria? So you can start with the first.
Excellent. Thank you so much. Well, to start with, we have a guarantee in Section 39 of our Constitution that provides for freedom of expression, which includes right to hold opinion, to access information and ideas, and to disseminate them. So let me be clear on this. Section 39, subsection 2, makes provision for entitlement of everyone to own and operate any medium, including digital media, whether it's your TikTok, Instagram, Facebook, or even X, to express yourself. And whether you are expressing academic views, artistic views, political views, gender views, or even religious views, then this right guarantees a protection for you. But then more importantly, we need to bring this up. I have actually heard some kind of phrases on the street where people will say, you have right before speech, but right after speech is not guaranteed. But I mean, it's so laughable that I've even had some lawyers echoing this. I need to let us or remind us this afternoon that you either have right to freedom of expression or you don't have it. The truth here is that right to freedom of expression essentially protects right to tell people or the state what they don't want to hear. Let me repeat myself. Right to freedom of expression essentially protects right to tell people or the state what they do not want to hear. Now, remember that when we say that right to freedom of expression includes right to own opinions. If, for example, my opinion about the president of the Federal Republic is that President Bola Ahmed Tinubu is incompetent, it is my opinion, and I have a constitutional protection for that. If my opinion about Mr. Peter Obi is that, look, this guy is unprepared, it is my opinion. If my opinion about Alhaji Atiku Abubakar is that this guy is just a jobless politician, it is my opinion, and it is protected. So when we look at that, freedom of expression is not just some kind of right that protects permissive or permitted views, but even views that disturb, shock, or offend people's sensibilities. So for me, I think that is what freedom of expression represents. Then the follow-up question, yes, of course, we've got legal and regulatory restrictions. Today, the Cybercrime Act is one of the biggest threats to freedom of expression. And of course, coming after that would be the deployment or use of criminal defamation laws at the state level. We know today, while the Cybercrime Act is a federal law, and states, a good number of states in Nigeria today have still maintained criminal defamation laws, while some other states don't have it. For example, in Lagos State today, criminal defamation is no longer an offense. And in Ekiti State, for example, but Oyo State, Delta State, Ogun State, and some other states in Nigeria still have criminal defamation in their laws. Can you hear me?
Okay, yes. Oh, thank you for that background. So what you are saying is the right to freedom of expression is a constitutionally guaranteed right. And because it is guaranteed by the Constitution, you have the right to hold your opinion, irrespective of whether that opinion pleases the government or pleases your neighbor or pleases whoever. So
Absolutely.
that's what I hear you say. Okay, thank you. I'll come back to you, Solomon. So I would go to Moji and ask her the same question. We are trying to get a proper grasp of what exactly is freedom of expression. So, like I earlier asked, so Moji, you give us your own definition of free expression in today's digital age, especially within the Nigerian and African context. And you also give us some insight regarding the legal or regulatory challenges currently facing online expression in Nigeria.
Okay,
Moji,
thank
over to
you very much. Yes, I'm here. I hope you can hear me.
Yes.
Okay, I understand the challenges of network and all that. It can be a handful. Let me see if I can engage my video because I see that you had done the spotlighting. Okay. Is it showing my video or not?
Yes, you can see. Yes.
Aha, perfect. So I think I just want interestingly, my brother and I, Solomon is my brother. We always think alike. When you asked that question, I am going to come from the perspective of the ICCPR, the International Covenant on Civil and Political Rights. I believe that is one of the best best instruments when you talk about human rights, political rights in internationally. And funny enough, it was as if the people who thought about the ICCPR actually saw the future when they inserted in that particular piece of drafting the fact that freedom of expression is your ability to express yourself, give your opinion, your views, and not only that, the media can also share information, and then you, in particular, can also access information over any medium. When I see the word medium, I get very excited. And that was one of the things that I've worked with in the courtroom. I get excited because the medium it transcends the present. It goes beyond now. It can go forever. Whatever is it that man's creation wants to think about if it's not the internet. So this is how I say it. So that medium means that whether it is in your physical environment or it is in the digital space, you have the ability to have, or you have the right to hold a view. You have the right to express that view, to give that view, to share it with others, to let them know that this is how I feel about this particular matter. And not only that, you have also the right to share information that you feel that you want other people to engage in. If you want people to actually discuss a particular thing that is troubling you, you can give it, whether you are in the physical environment or you are giving it over the internet. And we know that social media platform is not only the digital space. That is just one of the mediums in which you can express yourself. And so that's how I see that freedom of expression. And then I see it also from the perspective of somebody whose livelihood depends on sharing and accessing information. And that is talking about the media. The media's how do I put it? Strategic positioning in society itself. It's their life. Their commodity in general is information. So expression also covers the fact that you can share information and disseminate it over any medium, and that any medium can be anywhere, whether physical or in the digital space. Now, when we now come to whether the regulatory, legal and regulatory issues, I think that the first thing that comes to me, because apart from being a lawyer, I'm also no, I'm not driving. I can see your comments going. I'm not driving. I am parked. Don't worry. I had to leave a place that there was a blackout, internet blackout, or the network blackout. So I drove out onto a place where I know that there's network. So legal and regulatory issues that I can see. My brother has mentioned cyber crimes. That I will also say one thing: the regulatory issues that I foresee or I see that is a problem, apart from being legislations, they are legislations that carry vague meanings. Legislations that are so they carry words that are very ambiguous and can be subjected to different interpretations that can now be an impediment to freedom of expression. Yes, Cyber Crimes Act is one of the examples. The criminal code and the penal code, they are examples. And then, of course, we also have some specific regulations, like the lawful interception of communications regulation, for instance, of 2019. We have that, those particular those documents that can actually be a problem in the general perspective. And then there's also the fact that the legislative arm, there is an insistence on, let's say, for instance, they want to, they've been saying it, and we've been hearing it, whether in whispers or however, we've been hearing it about they want to regulate the social media. That is an impediment. It's a big issue. And because it's constantly an issue in the digital space. Let me see. There was one more thing I was thinking about before. Then there is always that issue of censorship. Censorship comes in different forms. There's a censorship that takes place when you have like a broadcasting code. When you see a broadcasting code that forces media to censor their guests or to censor themselves, you see that media does not do their job to the extent of their capacity. They are not able to do their job because they now have to self-censor and then have to think twice before putting out an information. And that's also cut across what we know in the international space as prior restraint. Where even though you have not made a law in respect of a particular thing, but people just have a general overview in that your environment that they should not make some certain comments when that even though it has not been, it is not explicitly stated that it is a crime. They just fear that when they express themselves in that particular manner, it will be criminalized. And so this is the general environment, which of course is also an impediment, a general environment that is now being sustained in the Nigerian environment as of today. When you are seeing a very, how do I put it, a situation of great impunity. And because of the impunity, you see where a journalist will report a particular information and the journalist will be picked up. Let me give you an example. There's a journalist that has been picked up by the police. Guess what? It's the same staff that we were informed that has been, what they call it, that word, that the same staff that we are supposed to know that does not exist again is the same staff that went to pick up this guy. And the guy is in staff custody as I'm speaking with you. And he has not been granted any access to lawyers. He has not been taken before the courts. He's just being detained in there, even though it's something that we are working on to take care of. So I'm giving that example of the environment itself is an impediment in actual fact when they're talking about the legal and regulatory. I hate when I miss my word, but I think you got the message. So thank you. Let me stop there then.
Yes. Okay. Thank you. Thank you very much. Thank you, Solomon and Moji. Thank you so much for that, very insightful opening. So you have really told us what freedom of expression is and what the law says about freedom of expression, and that is a right and is a constitutionally guaranteed right. And Moji also mentioned, when talking about the regulatory framework, there are certain laws that are ambiguous, they are vague. So maybe in the course of this conversation, you can suggest to us what needs to be done in respect of those laws that are vague, because we need to see how to ensure that the constitutional rights of citizens are guaranteed. But we'll proceed with the next question. To Solomon, you've been at the forefront of cases. For your profile, while I was reading your profile, I saw that you've been at the forefront of cases challenging provisions of the Cyber Crimes Act. So how would you assess Nigeria's progress in balancing free speech with cybersecurity regulation? Then we'll also like to know what key lessons can other African jurisdictions learn from the ECOWAS Court's decision on Nigeria's blasphemy laws. I know it's quite loaded, but I believe you are going to do justice to it.
Thank you so
you have the
much
floor, Solomon.
So starting with the first question, what progress have you actually made in respect of the cybercrime laws and of course, with free speech and all? The challenge I have with that perspective or that reality is the fact that we actually enacted a law that we did not need in the first instance. When you look at the Cybercrime Act, particularly the very draconian, Section 24, it was a piece of legislation that was actually lifted from the UK Post Office Act 1930, particularly Section 10. Now, and I can tell you categorically, if I give you now the hold or now repealed Section 24 of the Cybercrime Act, you read it and I take it away from you. If I give you Section 66A of the Information and Technology Act of India, you will tell me, Solomon, I just read it. I will say, no, it is not. If I take it away from you and I give you Section 29 of Kenya Communication and Information Act, you will tell me the same law you gave me, I have read twice. I will tell you no. It is a piece of legislation from 3 different countries. But one thing you will understand is that those 3 countries were they were previous colonies of the United Kingdom, the Great Britain. So, blindly, they all went to their former colonial master, copied their laws most of the time, and adopting in their bodies of law. Now, so in 2015, there was a challenge to that provision in India, and their Supreme Court actually rose to the occasion, struck it down, declared it unconstitutional. In 2017, in the case of Mandare and Heji, that particular piece of legislation came under judicial microscope, and the court looked at it and declared it unconstitutional. In 2017, the same thing happened in 2 cases. Pradham Initiative and the AG Federation and National Assembly, then Solomon Okedara and AGF. Well, our courts did what, I don't know, for some reasons, our court actually avoided answering the question that were asked in those suits, particularly at the Court of First Instance. That's the Federal High Court, then of course the Court of Appeal, and the 2 matters went as far as the Supreme Court. So my point is this: that provision contains very vague, ambiguous words. For example, what is grossly offensive? When even the act itself, in its interpretation section, does not determine or define what's grossly offensive. If I say, Ifeoma Ben is too fair for my liking. Now, some persons can feel like, okay, maybe Solomon doesn't like fair women or fair people. But then, should Ifeoma Ben consider that to be grossly offensive, it means I am liable to prosecution under that provision. Because the law itself does not define what will be the limit and the extent of grossly offensive. You'll be so shocked to realize that that law punishes needless anxiety. That you post something, whether on your Facebook or X, and somebody believes that needless anxiety has been created in their mind. And you can go to jail for as much as for up to 3 years, or pay a fine of 7 million naira, or both. So, but in 2024, that provision was actually amended. Now, here is the point why we need to look at if we have ever made progress or not. What, like grossly offensive, needless anxiety, intimidation, and all of that were removed. Then they left the word pornographic. So the question I need to ask anybody here is that, what is pornographic? The word pornographic, if you check dictionaries, including Black Law Dictionary, will tell you that capable of arousing sexual urge. Now the question is if a man appears shirtless, a woman somewhere can consider that the image of such a man as capable of arousing sexual urge. When you look at some of our skit makers that pass messages across, on digital platforms, they have skits that somebody can consider to be capable of arousing sexual urge. Cartoons we read in our newspapers and blogs and all of that. So when you look at it, this provision says when you send anything using digital platforms, then that is considered to be pornographic. Now, the question is that who will adjudge you to be pornographic? The law does not define. Then the law does not actually seek to punish revenge pornography or child pornography. So it just uses the word pornographic. So when you look at it, almost all of us in this room, can be liable under that law for sending what somebody, whoever may term it, pornographic. So if any politician, is actually offended, let's look at this gentleman, the guy who uses the stage name Governor Monike. Now, it does kids that actually send political messages. Now, if any politician feels offended, all they need to do is to write a petition to the police and, of course, cite the fact that his content are pornographic. And that young man will be arrested, prosecuted, and may be jailed for it. So another thing we need to know is that law does not actually, that provision does not actually define whether this excludes messages between people who have consensual, relationship. If Mr. A and Mr. B are in a relationship and Mr. A sends a message or some words or text message to Miss B, for whatever reason, if Miss B considers it pornographic, then Miss B can do a petition and Mr. A can be arrested and prosecuted. The other part of that provision says if you send anything, knowing it to be false, then for the purpose of causing breakdown of law and order, posting threat to life, you have committed a crime. So when will the law enforcement agency determine that tweet you have posted was the purpose of causing breakdown of law and order? Today, many arrests of journalists, bloggers, and certain journalists are being made on that provision of Section 24(1)(a) and B. So, and these are laws that do not have any need in being a body of laws. But because for whatever reason, we pick them somewhere, then after many challenges, constitutional challenges, we came back and said, okay, let us amend these laws. But in making an attempt to solve the problem, we ended up creating some other problems. So let me go to the next question. The next question, I think, borders on the blasphemy laws. That's a very interesting one. So let me first lay this foundation. The world over, there are well over close to 100 countries with provisions on blasphemy in their laws. But out of all of those countries, there are only 7 countries that have death-imposing blasphemy laws. Just only 7 of them. And Nigeria is one of them. Interestingly, the remaining 6 are actually Islamic states. Now, the point is that over time, we know that laws are actually legislated for some legitimate reasons. You need to maintain law and order in a society. That's fine. But when you have laws that actually impose excessive or disproportionate penalty, then you have created a problem. When you look at it all over the world, now, it has been said that, yes, while freedom of expression is not an absolute right, it can be limited in strict adherence with the rule of law. Now, all over the world, it has been created, so we have some tests. It's called 3-part test. 1, the restriction to freedom of expression has to be defined in a law. There must be a law. Then 2, it must be a process of legitimate objective. Then number 3, the penalty must not be excessive. When you look at the Section 382 of the Cardinal State Law that imposes death penalty on blasphemy words, whether to the religion or a prophet, it actually creates death penalty as the penalty. When if you go to Kano State or Katsina, you utter anything that's considered blasphemous. If you are fortunate enough, the person will be arrested, then prosecuted, and death penalty with that person. So what the ECOWAS court said is that, look, why attempting to maintain law and order in the society may be a legitimate reason for having a blasphemy law. But having death penalty as a penalty is excessive. It's disproportionate. You cannot kill someone for saying what they think is their opinion. Yes, you may want to discourage that, but killing them is excessive. Then about the other provision, the court said, look, when you are saying words that are likely to cause breach of peace, likelihood of causing breach of peace is vague, is ambiguous, is capable of, adopting or accommodating many interpretations. You can't have such a law in a democracy. And the court, of course, declared them as violations of freedom of expression and ordered the Nigerian government to amend or repeat those laws. Interestingly, just I think about 2 weeks ago, the ECOWAS court has now served a writ of execution on the Nigerian government. Now, which in a way has put the Nigerian government on a very hot seat to decide whether it will obey the judgment of the court or, of course, stand in disobedience. But for me, I think one thing that can be learned, whether the national courts in Nigeria or courts across, sub-Saharan Africa, is the fact that while freedom of expression is not absolute, restriction should be defined by law, number one. Two, be in process of legitimate objective. Perhaps it's maintenance of law and order, liberty of the state, or national security. And thirdly, it must not be disproportionate or excessive. Death sentence is rather reserved for extreme offenses like murder or terrorism.
Thank you so much, Solomon, for that very powerful insight. So I hear you, that certain provisions are vague in our laws. And I dare say, how do we ensure that there's this clarity always? Because this vagueness seems to be recurring in almost every legislation. You see that there's always one issue or the other. When the draftsman drafts certain provisions in the laws, they might have certain things in mind, but we are not in their minds. We are not there and cannot be there when they are drafting it. But you see that sometimes, and I believe most times, these laws, we have this public reading and the society is invited to make their input or make their observation. Is it that we don't really participate, actively in the lawmaking process? Why is it that we tend to bring out some of these issues after the law has been passed? I just think, yes.
When it was enacted, that law did not go through public reading. And there are two laws like that. That law and the current Nigerian Data Protection Act, they did not go through public reading, the two laws, interestingly. So you see, sometimes
and that's a very key issue.
And legislators over time, enact laws not essentially for the public good. Sometimes they enact law because there are some other personal incentives for them, which of course almost everyone in this room can understand. Legislators in Nigeria don't enact law because they like you, because they want to protect you. That's a fact.
I hear you. For such personal incentive is not for the good of the society. Of course, you are a legislature. You are the legislature to represent all of us. You are representing a constituency. You are expected, holding that legislative office to act in the best interest of the society. So it has to be objective. So I see this, there was this propaganda, this issue when the social media bill was at the floor of the House, a lot of controversy and all that. So you can start pinpointing some of these issues, whether it is for the public good or for the interest of those in power. But that's a discussion for another day. There are interesting perspectives here on the chart. I would get to them later on when we open the floor for discussion. But let me quickly go to Moji, who would also bring another perspective to the conversation, because I know I would love to hear her thoughts. Moji, I would love to hear your thoughts, on that. Especially, I know you have insight about regional human rights experience and all that. So, but let's go into the next aspect of the discussion. Your work in the Amnesty International and others against the Togo State case made waves globally. What impact did that decision have on the perception of internet shutdowns as human rights violation? And do you see progress towards the consistent African legal framework protecting online speech and digital rights? What do you have?
Thank you very much. The questions are, can you hear me?
Yes, I can hear you.
Okay, the questions are a mouthful, but just to quickly say something in respect of what Solomon had enunciated. Just on Monday or Tuesday, I think it was on Monday. On Monday, okay, let me backtrack. On Friday, the National Assembly advertised that there was going to be a public hearing of the digital economy, the National Digital Economy and E-Governance
Economy bill.
When they advertised that, yes, they advertised it on a Friday. Now, this was this is a piece of draft that they claim had gone through 36 states of the federation, and we were hearing for the first time. For someone like me who is in the digital rights space, I was hearing it for the first time on Friday. So what I did was on Monday, I went for that public hearing. When I got to the public hearing, I realized that only about 4 or 5 organizations had actually submitted a memoranda before that public hearing. And what did I find out? They were either government institutions or just 1 or 2 youth organizations. Now, the main people that are invested in digital rights in Nigeria, Civic Initiative, Accountability Lab, and several others like that, they were not aware that there was anything like a bill that was being considered for any reason. We didn't know prior to that. Guess what? The good thing was that I found out and I went for the public hearing, and I found out that among this group that I've mentioned, I was the only one that came to represent, and my organization gave a critical analysis. What I want to say to Solomon was that particular aspect of ambiguity and vagueness, it's almost as if it is deliberate, because it was a lawyer or a law firm that was given the job to draft this bill. And although I understand and appreciate the fact that they cannot know everything, or a bill cannot be 100% complete, that was why we also went in, and then we started doing our own kind of intervention and ensured that, as at yesterday, we have submitted other episodes. We have done a draft. We have done an edit on the bill itself. And so a coalition of these people that I've mentioned, these digital rights people, we had done a draft. We had imputed the right things, because we found out that there are going to be issues about privacy, issues of privacy violations in the near future, or even censorship, if that digital economy and e-governance bill was passed as it was. But we had made our submissions on the bill, or our corrections on the bill, and we sent it to the right quarters. And we hope that the National Assembly would adopt it the way it has been edited and corrected. This was work that was done on less than 24 hours. We did not sleep, and we have done that. I just want to say that when we know, we can actually do our best to correct what we want to correct. And even at that public hearing, I'm hearing them
Yes,
say that.
Moji, before you go, yes, before you go on. Yes, I wanted to say before you continue with the other part of the question. Yes, from what you just said, so I gather that we need to be more proactive. Yes, the public sector, the civil society organizations,
Private,
the
civil society.
yes, private establishments who are subject matter experts need to be more proactive, in especially in following up causes that they have interest in. If not that you said you had it and you now took steps, probably the input you would have made would have been lost. So we should be more proactive. And I say that I know some time ago, this digital economy bill, they've been talking about it, the Ministry of Communications, Innovation, and Digital Economy. There've been some conversation in this regard. And I believe also they should intentionally carry along some, interested
all
organizations.
stakeholders.
But I know yes, all
Yes.
stakeholders. I know they've done some, they've taken some steps, but sometimes also we as ourselves, even if they don't, when we hear anything happening in that regard, we should just run and say, we are here. You need to hear us. We need to make our input. So I just wanted to chip that in. So let's now go into the amnesty
yes,
question.
so let me now answer my question.
Yes.
Yes, please. So the Amnesty International Togo case was one case that it's a Lama case. It stood out because there were two factors that actually I think contributed to the kind of judgment that came up with the Amnesty International Togo. Prior to the judgment or the decision by the ECOWAS court, we have seen the high courts in India. We have seen them try to play around finding a way to pronounce on the fact that there is a right to the internet. They have tried it in a way. There are some cases like the Kreala case. They have tried to sort of like define it and say there is a right to the internet, but they have not been successful. Though they have not clearly stated it that it is a right. As at my last analysis or observation. But in this particular Togo case, there was an internet shutdown in 2017, and then we filed the case at the ECOWAS court in 2018. When we did that, we raised some pertinent questions, which were basically under Article 19, especially the three-part test, which is cumulative. They are cumulative. And the one says there should be a law in place if you're even going to restrict his freedom of expression. And if you can answer the fact that there is a law in place, that law must have pursued a legitimate aim. So your legitimate aim, you can come with national security, public safety, public health, in the democratic society for you to restrict that freedom, that particular freedom of expression. And that the measure that you are taking is the measure that is proportionate to that particular legitimate aim, which you claim is your justification. And so, when we presented these submissions before the court, the government came and said, "Oh, they felt it was a national security issue. Yeah, that there was going to be chaos, anarchy, and doom in quotes, and that was why they decided to shut down the internet and all that." However, they answered the questions. They answered the questions which you have asked. Was there a law in place? And they said there was no law in place. They came to court. That was their argument. There was no law in place, but they felt that any pronouncement coming from the executive arm, that particular one, you say executive order, that also communicates that there is a law that was that could justify the actions of the government. However, the ECOWAS court did not see eye to eye on this, and it was very beautiful for the court to, even though the court could have expanded its reasoning in that decision, but we're okay with the fact that COVID-19 happened in 2020. The court had not given its judgment. By June 2020, when the world had experienced COVID-19, and they are seeing what it means when the physical society becomes unbearable, or it's impossible to associate or to assembly or to meet, or when they saw the impact of having a shut down society, and then they saw the impact of everybody moving online. We started having religious activities, physical, different kinds, physical activities, people expressing themselves, and then the social media platforms became like a major lifeline for people. I think that this must have also influenced the decision. And so the good thing when that decision came was that it started boosting other decisions in other jurisdictions, started boosting local engagement in other countries. And so countries began to understand that, oh, wait a minute, yes, government has the right to say that they are pursuing a legitimate aim, but they do not have that right to just shut down the internet. They must be able to tell us that this measure that we took, or this measure that the government that they took, that measure was proportionate to whatever they were trying to address. And so that is where governments have not been able to respond to. And then we saw that every government, every society became proactive, or yes, became more aware of their, how do I put it, their power. The people became more aware of their power in this instance. And then they started making engagement, public engagement, then policy, and different kinds of interventions in fighting against internet shutdown. As this translated to internet not being shut down again? Of course not, because we understand that governments naturally can be recalcitrant. And so you will see that the follow-up issues were, of course, the judgment came in June 2020, and then we had seen that in 2021, Twitter was already banned for 222 days. And so we went back to court. And in this case, the court upheld this decision in the Amnesty International case. So that was also a good impact, because the court was emphatic that although there may not be a right to the internet as it is in a form, but the freedom of expression is a vehicle. Internet is a vehicle for you to express yourself. It's a vehicle. So the right to the internet is a derivative right of the right to freedom of expression. And then we saw this also, that with all that, though, there was still shutdown in Cameroon. Unfortunately, Cameroon is no longer a state that the ECOWAS court can cover. And then we still saw a shutdown in Guinea-Conakry. I still went to court against the Guinea-Conakry. The court still upheld this decision there. Then it happened again June 2024 in Senegal, June 1st. We still went to court. And then the court also, although the court has not given a judgment in my own case, but there was a sister case, and the court has still emphasized the fact that the internet is a derivative right, from the freedom of expression, and it cannot just be shut down, even if there is a law in place, even if it pursues a legitimate aim. You must be able to claim that it is the actions you are taking is proportionate. Now, that is one impact and one global response, and it has been very, very instructive for other governments, other jurisdictions. It has been very instructive. They use the Amnesty International Togo case as a precedent. And then you now said, do I see progress towards a consistent African legal framework protecting online speech and digital rights? I doubt it. I doubt if there would be that. There will be a progress, really. There will be a progress in the fact that we will see civil society consistently engaging. But I'm saying that the progress may not be at par with the fact that governments will continue to look for reasons to shut down digital rights, to continue to look for ways to not shut down. I want to use the word like to restrict, to curtail, the digital rights, and then they will keep looking for different forms to make speech online to be criminalized. We are seeing it happen in other jurisdictions. if you're thinking about the UK, Europe, and all that, is already happening. Even even the way they pick up people for expressing themselves. Of course, it's not as if we are not unaware that the fact that you have the right to freedom of expression, that you can say that right is absolute. Of course, we know that it is not absolute, and that is why I said there is a legitimate aim that the government can pursue, and the legitimate aim is national security, which of course is a very good one. But but of course, as I was saying, internet shutdown is just one part. There are other particular measures that government can take that falls under your digital rights, and they can curtail this. In fact, internet shutdown is the one that we know. The network disruptions, throttling, and blackouts that take place that we do not know. Like, you find out that in a place, I just told you that there was a blackout in an entire area. I had to drive out and I was wondering what was going on. I have not been able to decipher what the problem is, but I had to drive out just because I must make sure that I meet up this webinar. But I want to tell you that civil society is consistent in the African region. They are consistent in finding a balance. I belong to some of these particular different coalitions in the African region, and I can tell you that they are consistently looking for ways to balance it. They are looking for ways that we can protect the international human rights standards in the digital space, while as well also curtailing issues such as hate speech, disinformation, and the results from all these kind of actions or kind of offenses. And there is also the fact that sometimes you see civil society working with platform owners. And that's where you see issues about content moderation coming in. So the frameworks, of course, we'll keep developing them. We will keep
We are making efforts.
with the ones that.
Yeah,
so
there are efforts ongoing. Yes.
But if we will.
Yes. Yes, there are efforts ongoing. So, yeah. So thank you, Moji. Thank you. And as you are speaking, there was a suggestion here that came in through the chat that said the NBA should have a legislative watch committee. So I take it back to the leaders of the committee to push it through the NBA SLP and for consideration. Anyway, so now, as I was also going through the charts, I saw an interesting contribution, a comment that said that in as much as the Constitution guarantees freedom of expression and freedom, freedom of opinion and freedom of expression, not expression, that freedom is not unlimited. So it's essentially saying that no freedom is absolute. So that you have to, though you have the freedom to your own opinion, but that opinion should be expressed in such a way that the reputation of another person is not endangered. And it should also not amount to blackmail or defamation of character. So that there are consequences for such unguarded expression. So that now takes me to my next line of questions that border on freedom versus responsibility. So now, this question is to both speakers. So both speakers, I would like you to address this question, because as we are talking about, we are talking about freedom of expression being guaranteed in the Constitution. We should also look at if there are limitations. So how should this freedom of expression be? How should this right be exercised? Now, I will go to this question that I had earlier hinted that would border on freedom versus responsibility. So how can we strike the balance, the right balance between freedom of expression and curbing online harm, such as hate speech or misinformation? Then what role should social media companies play in regulating speech, and where should the law draw the line? So over to you, Solomon. You had the first bite on the cherry.
Great. That's a very interesting question. And I don't know whether you want me to actually merge that with the question I saw in the chat box. There was a question where a
Yes, Joe,
colleague
you can have, yes,
answered
you
the right.
can, yes, address both.
Okay, thank you. Now, you see, when I read through what uh, the colleague said, that's Richard Obiano, I realized that if he had gone through it for the second time, he most likely would actually not need my response or my clarification. And I would do that by going over what he wrote. He said, I want to disagree with Mr. Solomon that as much as the Constitution guarantees freedom of opinion and freedom of expression, that freedom is not unlimited. No freedom is absolute. You have the freedom to your own opinion. But if that opinion is expressed in such a way that the reputation of another is unnecessarily endangered, or that expression amounts to blackmail or defamation of character, there will be consequences for such unguarded expression. So express an opinion, ensure that opinion is verified, and all of that. Okay, so let me say this. I think this learned colleague actually mixes up what is opinion and what is a statement of fact. So let us unpack it. President Bola Ahmed Tinubu is incompetent. I mean, he has been in office for 2 years. He should have tackled terrorism better. President Bola Ahmed Tinubu stole 50 billion naira using the Lagos Calabar Coastal Road project. Now, can someone help me? Are the two statements opinions or statement of fact? Is one opinion or statement of fact? I want us to be able to get it. I hope we got these two statements. The first one
Yes.
says President Bola Ahmed Tinubu is incompetent. He should have tackled and put an end to terrorism in 2 years. And the
That
other
should be
one,
your opinion. Your
okay, the other
opinion.
one says President Bola Ahmed Tinubu stole 50 billion using the Lagos Calabar Coastal Road project. So what do you call the second one?
It can qualify as a statement of fact.
Statement of fact. Thank you. Now, the statement of fact, because I have put it forward, I have a responsibility to substantiate that fact. But may I ask for a statement of opinion? Do I need to substantiate my opinion? No, my opinion is my opinion. I don't have to like my president. I don't have to like my governor. I don't have to like my. I don't have to like anybody. And that's why, in the case of Andesite, versus United Kingdom, the court held that freedom of expression is not just freedom for opinions that we approve of, but including the ones that can disturb, shock, or offend the sensibility of the state or a sector of the society. So my opinion, the moment I have to censor my opinion, then I do not have freedom to express my opinion. My opinion is Nigeria cannot be one. Then you're saying I have to substantiate. How? That's my opinion. I didn't say my president stole money. So when we understand the difference between the two, we will understand why one, as a matter of fact, when you look at Section 39, right to hold opinion comes first out of the three limbs of the freedom of expression. Right to hold your opinion, you're human. That's one of the things that distinguishes us from animals. We can hold opinions. You can hold opinion different from your spouse. Saying your spouse stole is different from you believing that your spouse is arrogant. It's your opinion. So we need to understand that. So I said at the outset, right to freedom of expression is not absolute. But when you make some statement, a statement of fact, you have a responsibility to substantiate that statement, particularly if it's a statement of fact. Now, but when you make an opinion, you give an opinion, your opinion remains your opinion. So we need to understand the difference between the two. Then going further, so to answer the question that has to do with how to balance freedom of expression and the thin line between freedom of expression and the sanity on digital platforms. Let me say this. the reality is that even when it comes to hate speech, because some of these phenomena, they have very thin definition. They are very evasive in their nature. So what somebody may consider hate speech may not be termed hate speech by some other person. It was just like the phrase grossly offensive that previously existed in Section 24 of the Cybercrime Act. However, over the years, the civil society community around the world have actually distilled some parameters or factors to be able to consider that, look, these constitute the red line you cannot cross. So let's give an example. If Mr. Peter B makes a speech on his X handle and say, Igbos, take back your country, go to the National Assembly tomorrow, run over the legislators, and do the best you can do to actually stop the legislative proceedings. Now, if Nnamdi in Aba or Onitsha makes such a statement, most likely we will not consider Nnamdi's opinion. Nnamdi is just like every other citizen. But Mr. Peter B has grown in stature and status, political stature and status in the society, that his words may mean order to so many people. So when you look at that, they consider what is the status of the person who made the speech. Let's give another example. In what context was the speech made? Another factor, what is the proximity between the speech and the possibility of harm or chaos? Now, I have had privilege to train law enforcement agencies, police, SSS, and all of that. And one of the meetings, so we had a meeting at the beginning of the year in Lagos, and the then FFPRO made a speech that if you are using your Twitter handle or your Facebook and you record the video, you are calling somebody's name directly and you are cursing them, you have committed cyber stalking. That was the first thing we had to unpack. I said, listen, no. Oga police officer, that is not the law. That is not the law. When you look at the provision of Section 24, of the Cybercrime Act that provides for cyber stalking, it says when you use a digital platform to make some statement, and by the statement made on those digital platforms, you have put the victim or the person targeted in fear of their life or bodily injury, then you have committed the crime. So let's unpack it. Now, the former chief of defense staff said, President Bola Ahmed Tinubu, wherever we find you around my state or region, you are a dead man. And an orphan in Ikorodu, whose father just died. The mother died 10 years ago, the father just died as a soldier. And she could not get any benefit, severance benefit of the father. And of course, what else? She also could not get a loan from the NEF fund to pay her fee. Perhaps she's in the final year in the unit. And this girl now takes to her Facebook. She posts a video now and said, President Bola Ahmed Tinubu, my father served this nation with all his heart. He died. He couldn't get his severance benefit. I don't have money to pay my fee. Wherever I find you, I will strangulate you. You are a dead man. Now, the question is this. Can we look at these two situations? Now, can that girl, let's call that girl Shakirat, can the words of Shakirat put President Bola Ahmed Tinubu in fear of his life or bodily harm? Remember the fact that that man is the most protected African, or the protected African leaders, or one of them. But if an ex-serving chief, a military chief, made such a statement, then we should be concerned. All of us here will be bothered. Because the word of such a man should be able to put the president in fear because of what he's exposed to when it comes to security issues. So my point here is this. It is not just an automatic thing. Because somebody makes a statement on digital platforms, that threaten anybody. Just like you heard, Ifeoma, a 2-year-old girl cannot say, "Hi, Auntie Ifeoma, I will kill you today. I will kill you today." Now, you may not even reply the girl. But when a woman who is commissioner of police, in a state, tells you, "Ifeoma, I don't care that you're a lawyer, your life is not safe," all of us will be bothered, because that person has the capacity to carry out the threat. So when we are looking at it, it is very important for us to understand that, yes, oftentimes there's a thin line between freedom of expression and other vices. Yes, we understand for defamation, and the issue of criminal defamation is another subject. But what I'm saying here is that it is not just enough to say because of someone somewhere who is nameless, who is hopeless of the next meal, makes a statement, and we are saying, "Oh, then that fellow should be arrested." Now let me give you an example. I think there's a story of there's a gentleman who made a call for overthrow of the government, and I am aware that the DSS has filed a charge against that gentleman. You see, I can clearly say something. If a former chief of staff makes such a statement, we should be worried. If a former commissioner of police is worried. But you see, the fact that anybody makes a statement, so if tomorrow 500 people makes call for the government to be overthrown, then all of them should be arrested. And don't forget the fact that just a couple of weeks ago, there were actually stories about military officers who were caught, planning coup. Yes, why were they arrested? Because they have capacity. They have inherent capacity by their training, by their role, by their job, by their duties to overthrow a government. Whether they will succeed or not is another thing.
No, Solomon, yeah, sorry to cut it. So what I hear you say here is we need to look at the circumstances of the statement. We need to look at the status of the person making the statement, and also put it side by side with the provisions of the law. What does the law say about the actions of such people? What actions really amounts to violation of the law? So that's what I hear you say.
If I can tell you today, if you go to the Federal High Court, out of every 20 cybercrime charges, 19 of them don't secure any conviction. In fact, about 15 of them, they end up being abandoned because there's nothing to prove. They don't have the capacity to prove anything. So we can't just go about arresting people all over the place. So yes,
thank you, Solomon. I know you've given quite a lot of insight here and a lot of clarification, especially when you talked about give examples of statements that can be described as opinion, and other statements of facts, and also the circumstances and the context in which they are made. That was a very powerful one. So I know you have quite a lot to share, but I need to really look at the time now. So I would also bring Moji here to give our own insight on the same question, because it's quite important that while we talk about freedom, there is responsibility. So there has to be a balance between this freedom of expression and also the responsibility, our responsibility as citizens. We are expressing our rights. We also have responsibility. And I see also even some social media platforms are beginning to sort of regulate what we say or do online. You see that some people, even on Facebook, there are certain things, certain words you don't use now because there's some kind of maybe internal censor or something that they flag or report or even take down some pages or some profiles that have consistent or that make consistent use of certain kinds of words. So I think they're also playing some role there, but we are looking at what does the law say? Where should the law draw the line? So Moji, let's hear from you.
Hi, thank you. I wanted to say, in respect of your last statement that about social media platforms, I need to also actually um, say that as much as possible, that as much as we really want to find some kind of balance, which of course I will treat, as much as we want to find some balance in the social media space, we should not forget that the social media platforms and the tech guys, they are private persons, capitalists, whose business is just there to just go and make money. That's their first role. Their first role is let's go and make money. And then because they found societies that have been pushing back, like societies like Ireland, those ones, they know they waste time. When they've seen that, that's when they started making, efforts towards, let's find a way to moderate this particular content and all that. But I want to say that there is a flaw also in that system. We will not castigate everything. We will not say that, okay, it's bad in its entirety. But I have a problem with giving the power to platforms to actually moderate speeches, especially when it is not contextual. We have most of these social media platforms that are existing now, they are not created by Nigerians, and most of them are not even owned by Africans. They are owned by Western guys, and with their Western ideals. And so some expressions where we just they talk and we just they use that, make we just they flow for social media. Those algorithms, those systems they put in place actually censor us because they do not understand our context. And so that is where I draw the line. That's why I have issues with the fact that we can actually be censored even when we are right. And we can actually be censored even when the truth is our truth. It is our truth. And this is what we are telling, this is what we want to express ourselves on. So that is that. But because I want to express myself, or because I have the right under the Constitution, does not mean that I do not owe a responsibility. Every person who owns the right to expression, assembly, association, privacy, and others, they already know that those rights are not absolute in themselves. They owe a responsibility that in exercising that right, they are conscious of the rights of others. And so that is a clear, and it is a given. And so that is where you see that even when you want to express yourself, you must ensure that in expressing yourself, you do not express yourself in a way that would incite other people to crime, or that would incite other people to harming themselves, for instance. Or you say because you have the right to be on the internet, or you have the right to express yourself, you express yourself in a way that grooms a child to criminal activities, or radicalizing people. The terrorists actually use the internet to actually radicalize people. So so on one hand you have this rights, on the other hand you have a responsibility that in expressing yourself you do not breach the laws. You want to express yourself, but that does not give you the right to breach other people's privacy. You can't say because you like to take pictures and then put pictures all over the place, and then that means that I can just put anybody's picture in the social media place. If that person feels offended that you put their picture there, they have their own equal citizenry duty to hold you accountable.
Yeah.
That is a clear given.
Yes.
Then the second part of that
Incidentally,
question.
Yes, I think you actually talked about the second part first, where you talked
Yes,
about
I did.
social
I did. I
media.
just went.
Yes,
Just went.
yes.
Okay.
So incidentally, where your right ends, where another person's right begins. So your freedom is not absolute, you have responsibility. And so far, we've been talking about media, we've talked about a lot about media, various, medium of expression, freedom of expression, opinion. And now I won't end this discussion without talking about technology. I'm really a technology enthusiast, and I really would like to touch on areas that have to do with technology, the future of digital expression. And I would also want this, like the last round of questions that both speakers would answer before we take further questions and now wrap up the conversation. So now we'll be talking about the future of digital expression, we are just not, the technology, the internet, various things are coming up. Various technological tools are being utilized. Before you even try to get a good grasp of one today, you'll see that another one has been launched, and we are all trying to play catch up. So now, I would say, with emerging technologies like AI and deepfake, what new legal dilemma do you foresee for digital expression? And how can young lawyers, regulators, and the MBA contribute to shaping fairer digital expression policies in Nigeria? Yes, it's a twin question, but we can start with the first about emerging technologies. A lot is going on about AI, a lot about deepfake technologies, and there has been, in as much as we are trying to utilize technology, in our business, in our interactions, there are also certain challenges about the misuse of some of these technologies. And we know some international stories about some people who have been duped, an international company that have been duped, someone just having a meeting with, like we are on Zoom now, and you don't know that the people you seem to be discussing with are not the right people. You just have that business discussions, and you incidentally strike a deal in that meeting, and money moves from one place, from one account to the other, only for you to discuss or to discover later on that, oh, these people I thought were the people we were discussing with in respect of this deal, they're actually fake. And technology has made it look so real to you that you never suspected anything. So these are some of the challenges. So with these emerging technologies now, what new legal dilemma do you foresee for digital expression? So Solomon and Moji, whoever is ready to go first.
Okay, well, so a former president of the Supreme Court of Israel, said something. He said, change in social realities is the law of life, and responsiveness to change in social realities is the life of law. Let me say that again. Now, so what he's saying is that when social realities change, it is just living up to one of the laws of life, one of the laws of existence. But responsiveness of our laws to change in social realities, it is the core of the life of our laws. That our laws will only be seen to be living when they are responding to our social realities. Our social realities as at 2025 were not our social realities as at 1985. So the laws we had then could not actually live to the realities of our society today. So, but then again, you said something so apt in the introduction. Till tomorrow, laws will only be doing catching up with technological pace. I can tell you, and that applies in all human society, including the United States. You will never find a time. Why? Because the mind of man, desires or craves improvement at every time. So, and lawmaking process is slower than technological pace. So, what do? Yes, what we do is nothing new, but what we have been doing. Some centuries ago, there were issues of defamation, there were issues of incitement. Now, incitement then perhaps were restricted to the market square, town halls, where the chief can gather people, youth, and say, oh, let's go after the chief. Let's go to the chief's house. Let's burn it down and all of that. But today, the influencer, could sit down in the comfort of his room in Texas and could influence all of us, in the comfort of our rooms all over the world. So it's the same reality, only that technology has redefined the edges of that influence. So for me, I think the responsibilities fall on the shoulders of those who interpret our laws. We cannot be making laws at every given time. Maybe some people need to know this. Now, Nigeria today has a federal law on data protection and privacy. United States doesn't have a federal law. Yes, about 50 states have, federal, they have laws on data privacy. So United States have been having issues. I think they have just the fourth bill at the Congress last year. So what I'm saying here is that, look, the law was only begin catching up at every time. But men and women who are saddled with the responsibility of interpreting the laws to protect the right and protect law and order in the society have that sacred responsibility to look at it that, look, we have the law as of today. This law can still speak to this situation. Giving an example, before we ever have data protection, NDPA, Data Protection Act, we were litigating issue of privacy with the NDPR premised on Section 37. Before the NDPR, privacy was being litigated based only on Section 37. And our courts were speaking to those situations. So I believe that, yes, we are going to have legal dilemmas because the emerging technologies will not be expressly written or stated in our laws. But then all we need to do is to have the men who are saddled with that responsibility of protecting our rights. I mean, I'm talking about judges, to actually speak with their voices and expand the frontiers of the existing statutes to protect the rights and to protect the sanity in the society. About the NBA, young lawyers, and all of that, one thing we need to realize is that these laws, whether they are good or bad, they affect not only us, they can affect our future. They can affect our economic prosperity. They can determine whether we will live tomorrow or we will die tomorrow. So, particularly as men and women who are specially empowered, by way of our training, we should be sensitive to those things that go on in the society. Mojirayo mentioned the other time. It was, in fact, the fact that they announced does not actually mean they want you to come. But then, so knowing that is even the more reason why we should be more sensitive. We should actually put our ears on the ground, as they say, and be involved in the issue of lawmaking, because these laws affect us more than those people that make them. I think that's my view.
Thank you, Solomon. Thank you. We'll always continue to play catch up, but we can utilize what we have now to protect ourselves, to safeguard our rights, while we also amend where necessary in the future. So let's hear Moji still on the same question.
Okay,
so now just to recap the question. Yeah.
No, I get the question.
Please go ahead.
So I think one of the best things that have happened to humanity is technology. And without technology, we can't be having this conversation anyways. And we all know that the advantages of technologies, they are so widespread. But of course, it doesn't mean that there will not be one or two disadvantages. And so with the fact that we have artificial intelligence, in fact, I should say that deepfake was conceived first to protect how do I put it, to protect human rights activists, to protect defenders from intrusion, and also to protect people who had legit businesses that were not being considered businesses by government. You know, the way government exists, it can be very funny. If it's not the way government wants you to do it, then it is not a way. And unfortunately, I believe that there are ways that are very, very cogent and legit, that even though government don't want you to work in that part, it's because it does not serve their selfish interests. Let's agree that those things are there. E.g., blockchain technology, Bitcoin, it gives government a lot of headaches that we can actually exist without their influence in all those kind of, corner kind of places. Let's
And
put
they
it as
feel
corner.
threatened. They feel threatened.
Or the fact that we can circumvent their internet shutdowns. When they shut us down, we go to VPN. They pain them. It pains them because we can actually find all these circumventions. But that also tells to the versatility of humanity. Human beings are creative, they are innovative, and they will continue to be so. And so it's unfortunate that it's unfortunate that when we see the positive side of a particular technology, there will always be a negative side. So it means that those people who are negatively operating in the physical space that we have, they will also find how to operate in the online space. It's not like it's the online space that created the personality. The personalities already existed before the technology. So when you see people manipulating artificial intelligence in a way that is confusing people today, it is not the artificial intelligence, it is the person behind the artificial intelligence. And so what were the laws? I also concur with my brother that there are laws right now, whether we like it or not, there are laws right now that we can use to actually hold people liable. The definition of truth in 2025, you know that the definition of truth can actually be altered, and it can be altered with just one image, and the onus will now be on the person who is now trying to say, I was not the one in that picture, which should not ordinarily be. It should be on the people that are alleging that you were the one in that picture. But it sort of like just shifts the balance that we have known. But that does not mean that we cannot hold people who breach our sensibilities, who breach our human understanding of what the truth is. We cannot hold them responsible. We can still hold them responsible with laws. Like somebody was saying, technologically facilitated violence is happening in the online space. And I tell them, we do not need to draft a law that we will now call the technology of gender violence in the internet space, something like that. We don't need to have those laws because we have the criminal law, which is very, very applicable. We have the penal code, we have the Violence Against Persons Prohibition Act, we have the Child Rights Act, we have the Cyber Crimes Act. I am telling you this because I have drafted a prosecutorial manual for an organization, and I have shown and explicitly given directions that prosecutors reviewed that law, that draft, and they were like, exactly, they can move with this particular law to hold people responsible for online gender-based violence. It is something that we did not need to draft a new law for. But I'm just trying to say that although we know that technology will keep running ahead of us, but we can still always find a way to solve it in a way that will be that will not be to the detriment of our society. And so that is just in Shoki. Did you ask also about the other part of that question about?
Yes, I talked about the NBA, your lawyers. Yes, maybe if you can just so
I think one of the ways that we can shape a better digital what do you call it, a digital expression policy, in Nigeria. I think this is one of the ways. I need to say that when we are having this kind of engagements, of course, it helps us to reflect. It helps us to identify the issues, the challenges, and then as lawyers, it gives us the ability to critically analyze and profile solutions. And so, first, debates and engagements, you cannot take it away. Then capacity building is also one of the ways whereby people know what is their role. How can we be responsible in the digital expression sphere, and then also find a way to start bringing up ideas. And while we do that, we should also look at the kind of laws that we have in Nigeria. Those laws that we know laws to make them compatible with our present realities, which of course should not be that MBA is invested in it. And of course, MBA can be invested in when a section like the legal practice is also interested in it and bringing us to the table to come. So
thank you. Thank you so much. Thank you so much. I know we have we have had a lot to chew throughout this conversation. It's been raspberries back. They've just been giving us back-to-back insight on the topic. So thank you very much. And we just have, our time is up, but I just crave your indulgence to have 2 questions I answered by the discussant. I already have seen one, which was addressed to Solomon. He said, and a lot of people have been asking about CPD points, link, and all that. Damilola had earlier on addressed that to say that, if you have registered for this webinar, of course, you can't be here without registration. You should just sit back and relax. You would get your certificate. So it's just that simple. The file will be sent to the MBA ICLE and they will do the needful. And you get that in your email. So that's about that. Then this question that is directed to Solomon says, is from Geoffrey Nde. How possible will the judgment of the ECOWAS court be enforced and or obeyed, given that the federal government of Nigeria has in many cases neglected or refused to comply to such court judgments, including judgment of its own Supreme Court? Assuming that the FGN will be minded to accept the judgment, how will she force the Kano state governor or Kano state government to comply to that judgment? So, Solomon?
Yes. At this point, I do not, what is it called? I do not envy Nigerian government. And why did I say so? If you look at it, Nigerian government is one of the biggest funders of the ECOWAS court, as the judicial, arm of the ECOWAS community. And now, in fact, in 2023, I got a judgment against the Nigerian government where the court ordered Nigerian government to, within 6 months of the notification of that judgment, to file a report of compliance to the court. Now, interestingly, that was even the first time I would actually get such an order in the judgment of the court. But this time around, the court, about 2 weeks ago, served a writ of execution on the Nigerian government that you have to execute this judgment. So like I said, because even the subject is a very sensitive one, so I do not envy the Nigerian government. But let me say this, and for all intent and purposes, that suit was actually premised on Nigeria's obligation to uphold freedom of expression within its territory. Look, whether Nigeria operates a federal system of government or a unitary system of government, it does not matter to the community or its judicial arm. What matters is that Nigeria held itself out when it ratified those international treaties, those instruments that, look, as a nation, as a sovereign nation, we will ensure that freedom of expression is protected and is not violated other than in strict adherence to the rule of law, all within the territory of the Federal Republic of Nigeria. So our Nigerian government as a state party, we want that out will be its own headache. And that's the truth. So when you look at it, and again, let me also say this, that judgment does not only declare Kano State blasphemy laws as violation of freedom of expression, it declared all laws, all blasphemy laws in Nigeria. And that's why the judgment was those sections and similar laws. What that means is that all similar laws within the territory of the Federal Republic of Nigeria are affected by that judgment. So the question is, yes, whether Nigeria give effect to the writ of execution now served on it by the court or not, would actually speak to his intention to uphold human rights within the community, number one. Also, we actually speak to the legitimacy of the court itself. So if the Nigerian government decides to look the other way, then of course it already speaks so loud. And if the court, for whatever reason, refuses to sanction Nigerian government, then of course it calls to question its legitimacy to actually ensure that its judgments are enforced. All of us as lawyers know that when judgments cannot be enforced, then they are as good as they're just some worthless pieces of document. So for me, in days ahead, weeks ahead, months ahead, then both the court and the respondents would actually give us what their status will be when it comes to compliance and enforcement of the judgment. So I think I will leave it at that.
Yes, yes, yes. We have actually exceeded our time by 8 minutes. So thank you so much. I know our incredible speakers have a lot to share. And if you've been here from the beginning till now, you know that they've really given us a lot of nuggets, a lot to chew. So let's show some love. It's been a very engaging conversation. So I say thank you so much to our incredible speakers, Mr. Solomon Okedara and Ms. Mojirayo Ogunlana, for sharing such rich insights on the evolving landscape of free expression in our digital space, and for our very engaging participants. I say, kudos to you. They've been very active. I can see the chat box is quite busy. Everybody making comments, contributing. It's been a very wonderful session, very engaging. The speakers had a lot to share with us, and the participants were quite active. So thank you for joining and engaging with us today. And I would sign off shortly while I invite the vice chair of the subcommittee, TMT, to give us the closing remarks. So on that note, this concludes our session. I am Ifeoma Ben, and thank you for this opportunity of moderating this very engaging session. I now invite
Thank you. Thank
yes.
you. Thank you. Thank you so much. Thank you, Mom. It's been a very engaging conversation. Our speakers brought so much passion, energy. The energy in the room was really great. Thank you so much. I mean, we could go on and on this, and it's a very interesting conversation because, like Mr. Solomon said, one way or the other, this will touch everybody. This is like small chops. It will go around. It will touch everybody one way or the other, whether bad laws, improperly crafted laws, or the ambiguity in the laws, one way or the other, who knows who will be affected next. And there are people whose livelihood are tied to the ability to freely express using the internet as a medium. So as lawyers, I mean, it's easy to say NBA set up a liaison with the National Assembly, set up a legislative watch, but as lawyers, our responsibility is first to the society. We are vanguards, we are literal eagles. You see a public hearing going on a bill that you think would concern one thing. You can literally post on a group, talk to somebody, speak to a lawyer, show up. I agree with Mojirayo that at times some of these public hearing notices come so short that you're wondering that when you don't think people had other things going on in their lives before now. And at times it's a discouragement to not even show up. But let's try, let's show up, let's lend our voices, let's put in the extra work. And thank you. Want to appreciate our speakers. Interestingly, they are both very big players in the civic society as it relates to digital rights, and they're doing very tremendous work, not just in Nigeria, in the African landscape. So on this note, we are well beyond our time. I'll invite the alternate chair of the Media and Entertainment Subcommittee of the TMT, Mr. Adedumade Oniboku, for the closing remarks so that we can just quickly wrap this up. And before Mr. Adedumade, for those who are asking for the CPD link, I had announced earlier that in line with the new NBA ICLE directive, at the point of registering for the webinar, if you noticed, you were asked to fill in your Supreme Court number, your branch name. this is how we capture your details. So there will be no need to share links anymore. Your details were already captured at the point of registration. So there will be no CPD link anymore from this point. So Mr. Onibokun, please, you have the floor.
Yes, thank you so very much, particularly to our moderators and our speakers. Actually, the passion from both our speakers was very palpable. Like I could feel it here in the room. Thank you so much from the wonderful work both of you are doing in that space. And thank you for giving us an incredible time and sharing a lot of insights with us during this speech, during this session. I want to thank everyone who's attended. And I must say that on behalf of the MBA SLP chair, on behalf of the NBA SLP TMT Chair, and of course, on behalf of the NBA SLP Media and Entertainment Subcommittee Chair, I just want to say thank you to our speakers, thank you to everyone who's participated, and thank you to our moderator. I look forward to seeing every one of us in more of the sessions. I can assure you that there are very interesting sessions lined up for us to participate in, and I look forward to seeing everyone there. Thank you so very much.
Thank you.
Thank you, and thank you all.
Please stay tuned. We will be having these sessions every week, every Thursday. You can make it a date with us with our different subcommittees. We have something in the bag for you every Thursday. So please keep your eyes peeled, yes, for our very interesting and engaging sessions. Thank you so much once again to our very, very amazing moderator. I had a good time personally. So see you. Enjoy the rest of your evening. Thank you.